Hello, everyone, and welcome to Mayer Brown's Arbitrating COVID-19 Disputes webinar. My name is Eugen Tay, and I'm a partner in Mayer Brown's Singapore office and a member of our Global International Arbitration Practice Group. I shall be moderating the presentation today, and joining me as co-presenters are Jim Ferguson, Rachel O'Grady, Ulrich Helm, and Gustavo Fernandez. Before we begin, I've been asked to make a few housekeeping announcements, so please bear with me. First, please note that when accessing Mayer Brown webinars through our On24 platform, we recommend that you avoid using desktop virtualization software such as Citrix so as to minimize disruption to the quality of the transmission. Second, as there is an FAQ widget on the right side of your screen. Today's program is also being streamed through your computer, so there is no dial-in number. For the best audio quality, you should set your computer speakers to an appropriate volume. Third, we do encourage questions and we can take them during the presentation. If you'd like to ask a question, you should use the Q&A function at the bottom of your screen to submit. If you're facing any technical difficulties with the platform, you can also submit your questions by the same method. And if your questions are unanswered during the presentation because we run out of time, you're more than welcome to email the presenters directly, and we will be happy to follow up in due course. And finally, regarding CLE credits, we will provide an alphanumeric code at the end of the presentation. In order to receive your credit, you must record this code on the sign-in sheet, which would have been emailed to you with the login instructions for today's program. If you don't have the sign-in sheet, you can download it from the right side of your screen where there should be a widget that says resource list. So with those formalities out of the way, let's get started. We will hear first today from our so-called common law presenters, who will be Jim and Rachel. Jim Ferguson is a partner in our Chicago office who focuses his practice on US and international arbitration, particularly in cases involving IP and IT disputes. Rachel O'Grady is one of our star senior associates in the London office and also part of the International Arbitration Group. Her practice includes commercial arbitration, but also investment treaty arbitration under public international law. We will next hear from our civil law presenters, Ulrich and Gustavo. Ulrich Helm is an arbitration partner who heads our German disputes practice from the Frankfurt office. He is an authority on construction and infrastructure disputes with decades of experience behind him. And Gustavo Fernandez is a litigation and arbitration partner in our Rio de Janeiro office. He is both civil and common law trained, which makes him well suited to the comparative law survey we will be undertaking today. He has a diverse practice that is especially busy now in the areas of energy, infrastructure, and construction. So before I ask Jim to kick us off in a moment, let me first set the context for today's presentation. And I'm pleased to see that so many of you have attended. We had over 300 registrations. The title is Arbitrating COVID-19 Disputes. You don't need me to explain the economic disruption that has been wreaked by COVID-19, the COVID-19 pandemic worldwide. And such disruption has exposed businesses to loss, heightened economic and legal risks, with much uncertainty for the foreseeable future. Previously, the stable and predictable business sectors have been upended, and until a permanent solution is found to the pandemic, we are living in a new normal. In such times, we can expect a large number of disputes to arise, and many of these will be pandemic-related in the sense that they arise directly or indirectly from the impact of the pandemic, rather than simply from the conduct of a party. And that is the context for our presentation today. So our speakers will take us through the issues that are already arising or which we expect to arise in COVID-19 disputes. And as I've mentioned, we will first look at this from a common law point of view, then from a civil law point of view, and then knit some of these issues together. On that note, I invite Jim to kick off. You have control of the slides.
To set the stage for our presentation today, we're going to look first at 4 scenarios involving COVID-19 contract disputes. These scenarios have all arisen in just the last several months, and they provide good examples of the kinds of disputes we're going to be focusing on. In the first scenario, a U.S. buyer backs out of a contract to buy a global retail chain after the seller closes multiple stores worldwide due to COVID-19. In this scenario, the non-performing party, the buyer, is citing an adverse economic effect of COVID-19 as a justification for non-performance. And what I mean by adverse economic effect is such things as the loss of business, the loss of customers, anything that makes performance economically onerous. Let's look at the second scenario. A Chinese company purchasing natural gas from a French energy supplier tries to suspend its contractual obligations due to the sharp decline in demand following COVID-19. So this scenario also involves an economic hardship created by the pandemic. The Chinese buyer is in a long-term contract to purchase natural gas at a specified price. The pandemic causes a sharp decline in demand, and so performance becomes economically onerous. The Chinese buyer has to purchase the gas at a high price, but has no one to sell it to. Let's move to scenario number 3. A German supplier fails to deliver the required product to a Brazilian purchaser because a subcontractor defaulted following a loss of business due to COVID-19. Once again, an economic hardship created by the pandemic, in this case the loss of business, the subcontractor goes into bankruptcy, and as a result the German supplier is unable to perform. The fourth scenario, a conference organizer terminates a contract to schedule a June event in London after a UK order restricts gatherings of more than 100 people to slow the spread of the virus. A couple of things to notice here. First, in this fourth scenario, the justification for non-performance is not the pandemic, but an act of government resulting from the pandemic. Second, the non-performing party in this case is not saying that the governmental order made performance economically onerous. Instead, the non-performing party is claiming that the government act directly prevented performance. It made performance impossible. So the distinctions in these scenarios are important, particularly the distinction between creating economic hardship and actually preventing performance. And with these distinctions in mind, we want to now look at the potential defenses likely to rise under both the common law and the civil law in arbitrations of COVID-19 contract disputes. And we're going to turn first to the common law, where there are two common law defenses based on unexpected events like the COVID-19 pandemic. The first is force majeure, and the second is impossibility or frustration of purpose. The key thing to begin with in the case of force majeure under the common law is that it's strictly a creature of contract. What this means, of course, is that every case must be judged based on its specific facts and the specific language of the contract, but we can still establish a few general propositions. First, in general, to establish a valid force majeure defense under the common law, the non-performing party must show three things: an unforeseeable event that is beyond the party's control and that prevents or impedes performance. Classic examples include a natural disaster, acts of government, other acts beyond a party's control. These specified acts are typically set forth in the contract. The contract will also specify the remedies in the event of a valid force majeure occurrence. Typically, no liability for the duration of the force majeure event. And in some cases, the contract, under certain specified conditions, may authorize termination. In addition to these background principles, there are a couple of special issues involving force majeure under the common law. Economic hardship. Generally, under the common law, economic hardship will not qualify as a force majeure event even when it is a direct result of a force majeure event. Second special issue arises in the subcontractor context. A subcontractor default generally will not qualify as a force majeure event unless both the contractor and the subcontractor can meet the force majeure requirements. Let's take a look at one case to illustrate this background point about force majeure and economic hardship. This was a U.S. court decision. It involved a conference organizer who had reserved 500 hotel rooms for an event to occur in October 2001. After the 9/11 attacks, which were certainly unforeseeable, attendance plummeted and the organizer canceled the reservations, claiming force majeure. The court, however, held that the force majeure clause did not apply to economic hardship, even though the hardship resulted directly from the force majeure event. So, under the common law, the fact that an unexpected event has created an onerous economic condition is generally not enough to establish a force majeure event. Now that we've covered this background, we're going to move to the three key force majeure issues that are likely to arise under the common law in COVID-19 cases. This will be covered by my colleague, Rachel O'Grady in London. Rachel?
Thank you, Jim. Hello, everyone. So when looking at force majeure as a defense, there are three key issues, as Jim's highlighted, that we'll need to establish, and we're going to look briefly at each of these in turn. The first key issue is defining the triggering event itself. What exactly was it that was so unforeseeable that constituted the force majeure event? Secondly, it's not enough for a force majeure event to have just occurred. It must also have actually caused the party's non-performance, and it will be important to set out this causal link in order to prevail in any claim or in any defense. Thirdly, even if you manage to successfully define the triggering event and establish that it was the cause of your contractual failure, you may lose the right to rely on a force majeure defense if you have not complied with the notice requirements in the contract. So while this may at first glance seem a relatively minor issue, it's not at all, and cases have been won and lost on it, so it's important to address. So with respect to the first of these issues, defining the triggering event, it will be important, as I've just said, to establish exactly what the force majeure event is that has hindered contractual performance. And when doing this, it's helpful to bear in mind the causation requirements. Depending on the circumstances, it could be as general as the pandemic itself, if this is what's caused non-performance. Alternatively, it could be a very specific government restriction, shutdown, or a piece of emergency legislation, or a combination of all of those. Or it could be some other direct effect of the pandemic. But the definition of the specific triggering event and its duration, which we'll come to in a minute, will be relevant to virtually all other issues touching force majeure, including the causation, mitigation, adequacy of notice, and even remedies. When defining the triggering event, it will also be important to demonstrate, as Jim has said, that it was unforeseeable and truly unforeseeable. And this, in the current context, may become a highly contested issue, given the unforeseen nature of the pandemic and given that the timing of it is not really, well, it varies depending on the context in which you're talking about it. But unforeseeability is likely to be an issue if the relevant contract was formed in or after January 2020. As we all know, COVID-19 was declared a public health emergency of international concern on the 30th of January, and the World Health Organization declared it a pandemic on the 11th of March. But there is an argument that evidence, and therefore foreseeability, of the pandemic was clear even before these dates. So this is likely to be a highly contested issue if and when it arises in a dispute. Another area likely to become highly disputed is the duration of the force majeure event, and defining at exactly what stage it started and at what stage it stopped. And again, when the virus emerged is in itself not entirely clear, especially if you're trying to pinpoint an exact date for the purposes of a legal argument. The end point of a force majeure event in the context of COVID-19 is also unlikely to have been immediately evident, especially given that lockdown and other restrictions have generally been eased in various phases and as different governments have been taking different measures at different points in time. So the endpoint issue will be complicated further by the existence of any after effects as well, as these may also be found to form part of the force majeure event itself, if such after effects continue to prevent performance. And that's what happened in this case, which came before the English Court of Appeal some time ago now in 2012, but it looked at this exact point. And in this case, a supplier claimed force majeure based on both a general strike, which had resulted in the closure of ports, as well as the resulting congestion that happened after the strike ended. And in this case, the court agreed that the force majeure event included both the strike and its direct after effects, because the after effects themselves also delayed the performance of the contract by the party in question. Moving on to the second of our three issues, causation. Once we've defined the triggering event, we then need to establish the direct causal link between that event on the one hand and the failure to perform under the contract on the other hand. In addition to this, there's yet another further hurdle, which is that you'll need to show that the effects of the force majeure could not have been avoided or overcome. And I'm going to hand back to Jim in a minute to cover those last two bullet points. But first, looking at establishing the direct causal link, the wording of the contract will be very important, because this will set out whether the force majeure event must have prevented performance of the contract in its entirety, or whether it's sufficient for the purpose of the defence to simply have delayed performance or to have hindered it in some other way. But again, the height of the threshold will depend very much on the exact wording of the contract. And the contract wording will also reveal whether the force majeure event must be the sole cause of the non-performance, or whether there can be other contributing causes. In this ICC case, for example, the tribunal held that a triggering event may not have to be the sole cause of non-performance, unless that's what the contract said. So again, it will be important to really dissect the contract wording in order to reveal the exact scope of a force majeure defence, which will differ from contract to contract. I'm now going to hand back over to Jim to cover the remaining two aspects of causation.
Thanks,
Jim, you have control.
Thanks. As Rachel noted, the causation issue actually has three subparts, and the second subpart, in addition to establishing a direct causal nexus, is could the effects of the force majeure event have been avoided? In other words, the non-performing party must also show that it could not have avoided the effects of the events through the exercise of due diligence. A classic example involves a case in which the non-performing party cited a flood as a justification for non-performance, but the tribunal found that the flood did not excuse the supplier's failure to deliver goods destroyed by the flood, because the supplier could have avoided the water damage by packaging the goods in industry standard ways. What does this mean for COVID-19 cases? It means that a disputed issue is likely to focus on whether the non-performing party could have avoided the effects of the pandemic through the exercise of due diligence. This issue is sure to be the subject of expert testimony and also evidence of how other parties in the same industry, other similarly situated parties, dealt with the same force majeure event. In other words, if other companies had the same problems as the non-performing party, this evidence will support the non-performing party's force majeure claim. On the other hand, if the claimant can show that other companies were more successful in dealing with the effects of the pandemic, this will undermine the non-performing party's force majeure claim. The final element of the causation inquiry centers on whether the effects of the force majeure event could have been overcome. And this is closely related to the mitigation doctrine in common law, which requires a breaching party to take steps to mitigate the effects of the breach. In this context, the issue is whether the non-performing party could have overcome the effects of COVID-19 and if the non-performing party could have implemented a commercially reasonable substitute. If it could have implemented such a substitute but fails to do so, its non-performance will not be excused. We have, to illustrate this principle, an ICC case in which a company claimed that a U.S. government order banning travel to Libya prevented it from constructing a Libyan plant because the scheduled U.S. workers were not able to travel to Libya to complete the project. The tribunal rejected the claim because the company could have used non-U.S. workers. This was a commercially reasonable substitute. On the other hand, in another ICC case in which the non-performing party was citing a drought as a force majeure event, the claimant argued that the non-performing party could have shipped the necessary water from a source 250 miles away, but the tribunal concluded that that was not a commercially reasonable substitute. So what does that mean for COVID-19 cases? It means that a disputed issue is likely to be whether the non-performing party had alternative methods of performing the contract, and if so, whether such alternative methods were commercially reasonable. This again will be the subject of expert testimony, and once again, the evidence of how other parties in the same industry dealt with the same force majeure event will be relevant to this issue. This brings us to the final of the three issues in arbitrating COVID-19 disputes under the common law, notice, which Rachel will cover.
Thanks, Jim. So the third and final issue to consider with respect to the force majeure defence is whether, as I mentioned earlier, whether there is an actual requirement to give notice to the other contracting party of the force majeure event and its effect on contractual performance. In some contracts, such provisions constitute actual conditions precedent to being able to rely on the force majeure defence, whereas in other contracts, the notice requirement does exist, but it does not prevent a party from using the force majeure defence, even if such notice requirement is not met. And in those cases, the other party will likely still be entitled to sue for damages in the normal way, should the failure to notify have caused it any harm. And that's a case confirmed that's a point confirmed by the case cited at the bottom of this slide. So once again, and I'm sure you've all understood the point by now, but the wording of the contract will be essential because it will differ in each case. In looking at notice requirements, English courts have generally held that language is required, and very specific language, if the notice requirement is to serve as a condition precedent. So moving on now to impossibility and frustration. Whereas force majeure is a contractual defence in English law, unlike, as we'll hear in a minute, in some other civil law jurisdictions, in English law there is no general principle or doctrine that a party can rely on it if it doesn't have a force majeure provision in its contract. However, if your contract does not have a force majeure clause, or if it does but it's not possible to satisfy the relevant elements of force majeure that we've just discussed, in England, the party can still rely on the common law doctrine of impossibility or frustration. This is a doctrine that's available to contracting parties even if no provision is made for it in the contract. That said, it is a very, very tough test to meet, and courts and tribunals only grant it in exceptional circumstances. Similarly to force majeure, the doctrine requires an unforeseeable event to have occurred. But in this case, though, the event must have made contractual performance impossible, or it must have defeated the main purpose of the contract. If this can be shown, and if a causal link can be established with the event in question, then parties are able to treat the contract as terminated. So I'm now going to hand back to Eugene, who will pass over to our civil law colleagues so that we can see what remedies are available in those jurisdictions. Thank you.
Thank you to Jim and Rachel. And it's nice to see that we have well over 100 attendees from all around the world, with some familiar names attending late at night in Asia with me. So thank you for that. Just a reminder to those who joined slightly late, you are welcome to submit questions or even to share observations using the Q&A widget below, and we will leave some time at the end for discussion. Next, let me invite Ulrich to take us through some civil law perspectives before Gustavo does the same. Ulrich. Ulrich, just check that you are not still on mute, please.
Yeah. Thank you, Eugene, and in particular for the hint that I was on mute. In civil law, there are two concepts which can be used as COVID-19 defenses. The first one is the concept of force majeure, and the second one is hardship, often named as change in circumstances. Let's start with force majeure. There are some civil law countries like France, Brazil, China, Switzerland, which have almost the same concept in their codified law as in common law. So one does not need to agree in a contract, it's already in the law. And if there's nothing agreed in the contract, the law will be applied. The test is usually there has to be an event to be unforeseeable. And again, the crucial question in regard to COVID-19 will also under civil law jurisdictions be, at what point in time was COVID foreseeable? Secondly, the event must be beyond parties' control. Thirdly, it must prevent or impede performance. And if all these three prerequisites are met, the contract will be suspended. And we have a very good example of what, for instance, the French court decided only some days before 20th May of this year in an interim injunction in a case between Total and EDF. The commercial court in Paris qualified the coronavirus spread as an event of force majeure. As the spread was sudden and of wide extent, the court asserted that it was unpredictable, irresistible, and exterior to the parties, which are the three characteristics of force majeure I just mentioned, and under French law. The court now suspended the contract as the execution of the contractual obligations under reasonable economic decisions conditions had become impossible. However, in some codified laws, like German law, you will not find the concept of force majeure. So you might say, either I contract force majeure as a concept, which you can do. You are free to agree anything about force majeure, or I don't have that concept. But that's not true. Germany has instead the concept of impossibility, which is near the concept of frustration under common law, but not the same, since there is no tough test, but quite an easy test. Impossibility, first of all, is not defined in the law. It basically means any performance is prevented. No one can fulfill the contractual obligation is the base case. However, there is also impossibility if the debtor cannot fulfill the contractual obligation, but a third party can fulfill the obligation. And there's also impossibility if the debtor could fulfill the contractual obligation, but only with disproportionate effort. Impossibility can start initially with the signature of the contract or even before, and subsequently after the conclusion of the contract. And the last case is that success was owed but cannot be achieved. Hence, it is impossibility under German law if a sick patient gets healthy before the doctor arrives. In this case, in case of impossibility, the contract will not be suspended. The contract will stay in force. However, the rule is now no service, no consideration, no delivery, no payment. However, since the contract is not suspended, but only the main obligations, namely delivery and payment, damages can be claimed if the debtor culpably caused the impossibility. So let's conclude. In codified law, you do not need a force majeure clause in a contract. There is a force majeure concept in the law, whether it's named force majeure or impossibility. However, the prerequisites are different as well as the consequences. The concept of impossibility is clearly a bit broader than the concept of frustration under common law. I may now hand over to Gustavo, who will cover the concept of hardship or change in circumstances under a codified law jurisdiction. Gustavo, you have control of the slides.
Thank you, Rich. Thank you very much. Hello, everyone. The topic that I'll be covering now, which is change of circumstance or hardship, deals a little bit what we could name as the legal circumstances that the parties may face once the immediate effects of the pandemic are over. So the discussion here is once the lockdowns are down or off, either entirely or partially, what is being named now as the new normal may mean that we will have a different economy globally. So parties to a contract may have a different demand, a different overhead, different costs, and if this in fact derives from the pandemic, the parties may see themselves in a situation where the bases in which they have made their agreement are entirely different from what they could have reasonably foresaw. And of course, this is a very rare situation. In recent history, you could track this to maybe to the two world wars or to the crash of 1929. In other words, circumstances that are so harsh that dramatically change entire economies. So, and some systems have remedies for those situations that go beyond the discussion of force majeure, because as you have seen, force majeure deals with the impossibility to perform the contract either for a specific point of time or definitely if the impossibility is permanent. But what happens is that the situation is not that it's not impossible to perform, but it has become extremely hard, extremely economic onerous for one of the parties, and sometimes even creating advantages for the other. So in civil law systems, and this happens in France and Brazil, Italy also has specific provisions on that. Germany also has specific provisions in the law. The parties can ask either a court or a tribunal to revise the contracts, for example, to have a price revision or to have the quantities of a contract to be reviewed, or even to seek termination of the contract because of the economic imbalance that comes from the pandemic. So again, in terms of the civil law system, the advantage that those parties have is that the legal codes or at least the case law interpreting those codes have specific solutions for those situations. And the same happens with international instruments. So the UNITRA principles also contemplate change of circumstance that allows a court or tribunal to revise or terminate a contract, and the same with the regulations on the European principles of contract law. And the issues that normally emerge on those discussions are, first, whether there's an obligation of the parties to negotiate an amendment or revision of the contract. Of course, the difficulty here is if there's an obligation, what is the breach? What is the consequence for not complying with this obligation? So leaving aside the very theoretical discussions, what a practical conclusion is that if the interested party does not negotiate before seeking revision or termination, it's fair to assume that the party will have some difficulties in being successful in the dispute. So the party should, if they seek to revise or terminate the contract, a previous negotiation is advisable. As to the jurisdiction of courts and arbitrators, this used to be an issue, mainly because, especially when you seek termination, it's so to speak, it's a remedy that courts normally will not have an issue with dealing with that. But when it comes to contract review, what the parties are actually seeking is they're seeking the courts to be redrafting an agreement without the problems and complexities that derive from that situation. So normally, the way that those claims are presented, the interested party needs to present what that party seeks in terms of revision. So it has to present a new formula, a new price, or a new combination of price and quantities. In other words, the interested party needs to give elements that both the respondent can challenge, showing that the proposed solution is not workable or is more onerous than the current situation, and also that the tribunal or the arbitrators can revise. So what we have seen here in terms of disputes is, and this is sort of a prediction, is that once the situation with the lockdown is entirely or at least partially resolved, what probably we are going to see, especially in civil law system, is the revival of those disputes when the parties are not wants to preserve the contract because the contract is necessary for a specific need, but to ask the court or the tribunal to review its terms. So it's I believe that parties need to be well prepared for that because that requires a very complex homework to be done before the actual disputes initiate. So so that was my part on here. Eugene, I don't know if I go back to you.
Thank you, Gustavo. So we are doing quite well for time. It is. I think we can get to some concluding remarks, and then hopefully a little bit of a discussion among our panel today. So we have settled a slide on slide 31, a table on slide 31, I beg your pardon, which sets out in tabular form some of the comparative elements we've discussed. I'm not going to go through that. I'll leave you to refer to that. And I'll turn on to slide 32. There are three simple takeaways. They are as follows. One of the things we've learned is in common and civil law jurisdictions, these COVID-19 disputes are likely to involve what we could term as pandemic-based defenses. And at the moment, these are likely to require some showing of unforeseeability. As Rachel mentioned, this is an area that could be contentious and can see some diverging decisions. As Gustavo mentioned, the very interesting area of legal development is going to arise in relation to economic hardship or change in circumstances, which can, in sufficient extremity, provide grounds for a defense. In certain circumstances, it might even not be a defense, it might actually be the affirmative action. But what's important here is that this arises only in civil law governed disputes, not in common law ones. And on a related note, civil law remedies can be very wide and can include an obligation to renegotiate and possibly revision by a court or arbitral tribunal if that renegotiation doesn't lead to an amicable result. Now I have the privilege as moderator to share some additional personal takeaways, which I've certainly gleaned in preparing for this event. And the first is this. Regardless of whether you come from a common or civil law background, we are, as you know, we're likely to start with the language in the contract. And this is especially so, as we've heard, in relation to force majeure. The contract provides the starting point for analyzing whether the force majeure has been triggered. But this is linked to the second point, which is that the governing law is going to be critical. Because obviously, if the governing law is that of a civil law system, you will then have to consider, as Ulrich explained, how the contract's force majeure provisions interact with the general codified law. And here, many civil law countries with force majeure doctrines do not necessarily regard those rules in the codified law as mandatory law rules, which means that parties can expressly contract out of them. And what this also means is that in such civil law countries, the contract can be decisive, and there may not be a huge difference between the common and civil law triggering events. You start and end with the contract. But this leads to a third takeaway, which is even if you're from a civil law country, don't assume that all civil law countries are the same. This is where we have a great area of complexity. And I see, as I mentioned, I see some familiar names, and I know the types of questions you're interested in. In Asia, where I focus my practice, China, for instance, stands out as a country where force majeure is in the codified law. And force majeure in China can trump the contract, even if you have a more restrictive notion of force majeure there. In contrast, in another large civil law market like Vietnam, the answer is unclear. And in yet another civil law market that's important, in Indonesia, the answer is generally yes, but again, there is a variance in the way that courts and tribunals apply the rules. So this issue of whether some of these doctrines are mandatory or not mandatory and whether you can contract out of them is an area of uncertainty and complexity in some instances. A next takeaway is really my bias. We've learned that if the governing law is a common law, then apart from establishing the triggering event, such as whether force majeure has occurred, issues like causation, mitigation of damages, formalities like notices, these are the things that are interesting and critical to common law lawyers and the common law mindset in determining the ultimate outcome of the case. But in my experience, if a civil law applied, while these issues may still be important, a civil law approach may not be as fixated on precisely separating out these considerations. And my fifth takeaway is that, as Gustavo has mentioned, I think it's the area of hardship or fundamental change of circumstances in a COVID-19 world that is going to be an interesting area of new disputes. Particularly as we are faced in many industries with what is a new normal, by definition, as I mentioned, a fundamentally changed set of economic circumstances. And in such scenarios, parties may be able to seek revision of contractual agreements. Clients who are, or parties who are now considering making investments in a COVID-19 world where the contract may be governed by a civil law should take care to understand how this particular doctrine works. And as I mentioned, the civil law jurisdictions are different, even if the various of them have the same concept. And it will be important to know whether you can contract out of this doctrine. One of the types of change in circumstances are often going to be relating to economic change. So, for example, a change in the elements that dictate the price of the contract. And we're starting to see a lot of these in the energy sector, particularly in relation to commodities pricing. And classic example is the area of LNG price reviews, where there is history of the contracts containing a change of circumstances type doctrine. In these cases, in terms of practice, for those of you who are litigators and arbitrators, the difference is that expert testimony doesn't just come into play at the end, at the quantum stage. Expert testimony tends to play a major role in evidencing the triggering event in the first place, and therefore experts have a large role to play. The other interesting aspect of such cases, if the dispute is over economic hardship, is that the case may not necessarily be fault-driven. It can be a purely economic trigger. I see that we have some questions that have come in from the audience. Some of them are being responded to you in writing, but if I may now turn some questions to the speakers. Gustavo, we've got a question for you. Is it possible to contract out of the fundamental change of circumstances doctrine or the hardship doctrine?
Thank you, Jane. This is a very good question, because when this is asked with respect to force majeure, there's no question at all. The parties, of course, can opt out of force majeure entirely or partially, define situations in which it applies or doesn't. When it comes to hardship, we still don't have a specific case dealing with that. What we have so far are a few comments on legal scholars. Some seeing this the right to seek revision as a mandatory provision in the civil code, and therefore, if it is a mandatory provision, a waiver would not be proper. But I fail to see the substantive difference between waiving a force majeure situation and hardship. They should have the same treatment. I don't see why the parties could also deal with that in the contract and restrict or even exclude hardship. But this is yet to be decided. At least here in Brazil, there's no clear court case to indicate a solution.
That's very interesting. So if I turn this question now over to Jim and Rachel, having heard from our civil law colleagues about the potentially wide scope of operation of the hardship or change of circumstances doctrine, as seasoned litigators, how would you advise our clients to manage their risks in dealing with this unknown, particularly if they are entering into, say, a distressed acquisition at this time, operating in a context where such doctrines could apply because of the governing law?
I'll take the first cut at that, Rachel, and then you can supplement, if that's all right.
Fine by me.
So one of the most important legal consequences of the COVID-19 pandemic, in my view, is that it has incentivized companies worldwide to give more attention to contractual provisions dealing with risk allocation than they previously had. In the past, force majeure provisions, for example, tended to be boilerplate. Now that we have an example of a worldwide crisis that has had profound economic implications, many of our clients are coming to us and asking us about the most effective ways to allocate risks in different across all industries and in all contracts. all kinds of contracts, M&A contracts, supply agreements, tech transactions, IP licenses. And so the short answer, Eugen, to your question is what once was boilerplate has now moved to the top of the list of important items to be negotiated in any contract, and that is how to allocate risks. Now, in all of these situations, or in many of these situations, one party is going to have more negotiating leverage, and that party, therefore, will have various options to convert that advantage into so-called leverage provisions in the contract. For example, it could insist that if the other party invokes force majeure, that only the performing party would have the right to terminate, or the performing party would have the right to suspend all payment. These are the types of considerations that companies now have to focus on in light of the COVID-19 example. One other point I want to make related to this is now that we do have the COVID-19 example, unforeseeability may be more challenging to establish in the future. If we were to have, for example, a mutated form of the virus or some completely novel virus emerge in 5 years, it will be a disputed issue as to whether the consequences of that were unforeseeable in light of the experience that we're now going through. So all of this underlines the importance of paying attention to risk allocation provisions in drafting agreements in virtually every sector of the economy. Rachel?
Yeah, thanks, Jim. You took the words right out of my mouth, and I agree with everything that you've said. The only thing that I would add would be in undertaking that risk allocation exercise with so much more focus, I think a big part of it will not just be drafting wider clauses and more specific clauses to take account of eventualities that we may not have previously foreseen, but it will also involve more due diligence on the potential law that you're going to apply to your contract, and that's going to be necessary as evidenced by our conversation today, because depending on which law the contract is subject to could result in a whole variety of different outcomes, especially with regard to these defences. So obviously I'm very biased and I would say, you know, subject your contract to English law, but I mean it's going to be a much bigger part of a much bigger consideration to take into account, as you say, that these clauses are not just going to be boilerplate anymore. They're going to be really important, and so as part of that process, I would just recommend doing more due diligence at that outset, rather than just, you know, subjecting something to English law, American law, wherever. But think about these considerations and kind of follow through the potential scenarios that might occur in the future and kind of preempt them in your contracts.
Thank you both. And I know from from looking at the list of attendees that some of our clients on the call are doing business and making investments, large investments in countries like Vietnam. Vietnam, for instance, only recently in 2015 introduced this notion of change in circumstances or hardship into their law. And there has yet to be a great understanding of that, and particularly it hasn't been tested before the courts. So one of the expectations on my side of the world is that we are going to see this area of law being developed soon, and that is a significant uncertainty for parties. So we're expecting to see disputes. There is a question here for, I think it would be for Gustavo or Ulrich, and it's this. How does assuming that a tribunal or court is asked to revise the contract, how would they go about doing that? Are there any rules that would control how the contract should be revised?
German law, let's say the system is as follows. Parties are required to negotiate amicably modifications to the contract, and if they don't do, they can't go to the court. They will not lose their entitlement to a modification, but they can't go to court. So they need to do that. And obviously they fail. And then one party is approaching the court with a defined, let's say, wish for modification. And the court says either yes or no. Or they say the contract needs to be modified as follows. And as a consequence of this modification, the other party owes us X euro, whatever. And then they sue the other parties only for the money. And there will be a decision which answers the question whether they have a claim for modification. And consequently, with the consequence whether they get money or not in one decision. So that's if the court says no to the modification claim, the court can, let's say, make proposals and say, well, we give you less than you ask for, but they can't give them more because they're bound to what has been applied as a general rule in law. So I hand over to Gustavo. How is it in Brazil?
Gustavo, are you on mute?
I'm sorry. Yeah, I was on mute here. I'm sorry. I was saying that it would be very similar here. There would be no much different from what Ulrich has described.
And this is a question from me. In the context of LNG price review disputes that I've handled, that's a situation which I, as a common law lawyer, do encounter the equivalent of change of circumstances. But the interesting thing is that on a contractual basis, either party can ask for a revision of, say, the price in the contract. It looks like we are at the 1 hour mark. Do any of my co-presenters have any observations or remarks to share?
This is Jim.
Yep.
We've had several requests for citations to some of the cases that we cited in our common law discussion, and I think the easiest way to handle that is to respond to each of the requests individually by email, but we will be happy to provide the citations to the ICC and other cases that we cited in our discussion of the common law doctrine.
Absolutely. Thank you for that. It's late for those of you attending in Asia, so we will keep to our time. We have received a number of questions that we will not have time to discuss on the panel today, but we will follow up with you directly on email for those. And if any of you have any other thoughts or questions or observations to share following the presentation, please do get in touch with us by email. We will be happy to chat with you. And finally, thank you for joining. This concludes today's webinar.